Good morning and welcome to the first in a five-part series of webinars dealing with the prosecution, defense, treatment, and community supervision of adult and juvenile sex offenders. My name is Michael Lasco and I'm the Chief Probation Officer for Morris and Sussex Counties and moderator for today's webinar. There are offenders who engage in illegal sexual acts who are not ultimately classified as Megan's Law, and this series of webinars will explain how all these cases, both Megan's Law and non-Megan's Law cases, are processed through the New Jersey judicial system. This series was developed in a partnership between the New Jersey Division of Probation Services and the New Jersey Association for the Treatment of Sexual Abusers, or more commonly known as NJATSA, who funded this project. We are very grateful for support we have received from all participating agencies, including the New Jersey Office of Public Defender, the New Jersey Division of Child Protection and Permanency, or DCP&P, the Camden County Prosecutor's Office, and the Union County Prosecutor's Office. Our goal is to provide stakeholders and the general public an opportunity to learn how sex offender cases are processed. It will include information on case disposition options used by the prosecutor and the defense attorney, treatment options, and how reunification with the family is handled in cases of incest, the role that DCP&P plays in these cases, and the differences between how juvenile and adult sex offenders are handled in the justice system. This webinar is approximately 1 hour, 15 minutes long, which includes a 15-minute time slot to take questions from the audience. Within 2 weeks of the live webinar, will be posted on the NJATSA website for ongoing access by both stakeholders and the general public. Today's webinar topic is the prosecution and defense of adult sex offenders. Matthew Spence from the Camden County Prosecutor's Office will address the prosecution of adult sex offenders, and Stephanie Lutz from the Office of the Public Defender, who will address the defense of adult sex offenders. Both presentations will provide a legal overview, collateral consequences, dispositional options, tiering information, and removal from Megan's Law. We will now start our presentation with Assistant Prosecutor Matthew Spence. Mr. Spence has been employed by the Camden County Prosecutor's Office for over 19 years and has been supervising the Megan's Law unit for 5 years. Good morning, Matt.
Good morning. Ladies and gentlemen, this is Megan's Law, What You Need to Know. This is essentially a primer for the basics of Megan's Law. It's meant to give you an overview of what Megan's Law is and, more importantly, what it is not, as there are several misconceptions as to what Megan's Law does and does not do. Megan's Law itself was enacted on October the 31st of 1994. This was done in response to the rape and murder of Megan Kanka by Jesse Temendequaz, a registered sex offender, on July 29th of 1994. It should be noted to most of you that this law was passed in a great hurry. The act itself occurred on July 29th, and yet we passed a law about this less than 6 months later. Megan's Law is designed only for notification and registration of sex offenders. That is all that Megan's Law does. The New Jersey statute in question is 2C7-2 and runs through 2C7-23. Megan's Law itself is considered civil in nature and is considered to be non-punitive. To be on Megan's Law, there must be what's called a qualifying conviction. The predicate act, in order to be on Megan's Law, you must be convicted, adjudicated delinquent, or found not guilty by reason of insanity of a qualifying sex offense in this state, or any similar crime from another state or federal institution. The qualifying sex offenses are aggravated sexual assault, aggravated criminal sexual contact, kidnapping, endangering the welfare of a child by impairing or debauching the morals of a child under 2C24-4A, possession of child pornography. It should be noted that the possession of child pornography statute was just passed on February 1st of 2018, and it does not include crimes committed for that offense. Manufacturing child pornography, distribution of child pornography, luring or enticing, criminal sexual contact where the victim is a minor and the offender is not a parent, criminal restraint, false imprisonment if the victim is a minor and the offender is not a parent, false imprisonment if the victim is a minor, the offender is not a parent, and promoting the prostitution of a child. And this is important, or any attempt to commit these acts. The date of conviction must be after October the 31st, 1994, unless the sentence was being served, the registrant was on parole or probation or civilly committed at the time for that offense, or if the registrant was found to be repetitive and compulsive of a qualifying conviction. For registrants, what they need to know is that they must register within 48 hours of the release from incarceration. If they fail to do so, they could be charged with failure to register, which is a third-degree crime in New Jersey, and can lead to 5 years imprisonment. The registrants must go to their local police department where they intend to reside. If they don't have a local police department, then they register at the local state police barrack. It is the registrant's obligation to register. The state has no obligation to remind the registrants to register. If they don't do so, they do it at their own risk. Registrants must register once per year, unless there is a finding by clear and convincing evidence that they are repetitive and compulsive at the time of sentencing. If that is the case, they must register it every 90 days. And to be clear, every sex offense that is pled in the state of New Jersey is subject to an Juvenile evaluation. That is when it is determined whether or not a registrant is repetitive and compulsive. And that is done at the time of sentencing. Failure to register is a third-degree offense. Again, it carries a maximum penalty of 5 years state prison, and violators could be subject to an extended term sentences depending on the record. When one registers at the local police department, here is what to expect. Most departments have a Megan's Law liaison officer. A registrant may have to schedule an appointment if the officer is not working. When they go to register, they will have the photographs taken every single time they register. The officers may photograph their vehicles, and they may photograph any tattoos. Registrants will be fingerprinted or put on a live scan every time they register. There is a form that is filled out, the Megan's Law registration form. They must fill that form out in total. Typically, the officer will ask the questions and have the resident sign the form when it is complete after they've reviewed it. They will review, initial, and sign what's called a Megan's Law Acknowledgement of Duties and Obligations form. This form outlines all of the registrant's responsibilities under Megan's Law. Registrants will have to bring a photo ID and proof of residence when they go to register. The police will then verify their address at a later date. And by that, they will actually go out to the house and see if anybody is living there and verify that they are indeed living in that home. The acknowledgement of duties form is filled out every single time a registrant registers. It lists 10 things that every registrant needs to know and needs to understand. And after they are read it, they initial it and sign the bottom of it. It should be noted that the prosecution in every single Megan's Law violation case will use this document in evidence to show that the registrant understood their rights and obligations. The first is that I understand that I must verify my address with the police department where I live every year, or if my municipality doesn't have a local police department, with the state police every 90 days with the local police department, or if my municipality does not have a local police department with the state police, if I am found to be repetitive and compulsive sex offender. 2, I understand that this verification must be in person, and I must provide proof of that address, such as a letter or a bill. And I understand that verification is due on the anniversary of my initial registration or most recent re-registration from a change of address. I understand that I may be charged with a failure to verify my address, a third-degree offense, if I fail to comply. I understand if I move, I must notify the local police department where I am registered and the police department where I intend to live at least 10 days prior to moving. I must then re-register in my new town. Verification of that address is due the year after the re-registration. I I understand that if I move out of New Jersey and then move back to New Jersey, I must re-register within 10 days of returning to the state with the local police department in the town where I live. I understand that if I move to another state, I will be subject to any and all laws governing sex offender registration. There are procedures in that state. I understand if I work or attend school in another state, but remain a New Jersey registrant, I must register in the state where I'm employed or attend school. This out-of-state registration is in addition to the registration in my hometown and does not change my obligation to register where I live in New Jersey. 5, I understand that if I enroll and work in a post-secondary educational institution in New Jersey on a full or part-time basis, I must register within 10 days of commencement of such attendance or employment with the law enforcement unit of the educational institution, or if no law enforcement exists, with the local police department having primary jurisdiction over the campus. 6, I must understand that I notify the police department with which I am registered in person of any change of employment or school enrollment status within 5 days of such a change. I understand that I must register with the chief law enforcement officer of that municipality in which I intend to reside within 48 hours of my release from this institution. And I understand that I may be charged with failure to register or re-register as required by law. I understand that if I remain arrest-free or offense-free, for 15 years from the date of conviction or release from prison, whichever is later, I may apply to the Superior Court of New Jersey to be relieved of my obligation to register, unless I have more than one sex offense, or if any of the offenses were aggravated sexual assault or sexual assault in violation of 2C 14-2C1. 9, I understand I cannot hold a position or otherwise participate in an unpaid or paid capacity in a youth serving organization. I understand that a youth serving organization means a sports team, league, athletic association, or any other corporation, association, or organization, excluding public and non-public schools, which provide recreational, educational, cultural, social, charitable, or other services to persons less than 18 years of age. And I understand that non-compliance with this duty subjects me to being charged with a crime that carries a penalty of up to 5 years in prison. I understand that if I consider myself homeless, I must select the town and location where I spend the majority of my time and register in that town and location in order to fulfill my registration obligation. The registrant then signs and dates the document. This document is reviewed and signed at every registration and re-registration. So it's clear, every time a registrant intends to move, it is their responsibility to notify the police in the town where they currently reside, as well as notify the new town 10 days prior to the move. When they notify the current town, they fill out and sign what's called a relocation form. That form is then emailed or faxed to the receiving municipality, where they will await the registrant to come in and register. Computers with Megan's Law. As part of Megan's Law, when registering or dealing with probation or parole, a registrant must disclose whether they own or have access to any device that has internet capability. That could be a computer, a phone, a game console, anything that has internet capability. Failure to disclose or providing false information about the registrant's access to the internet access device is a crime of the 3rd degree. And so it's clear Megan's Law does not prohibit ownership of those items. However, they must be disclosed. Under Megan's Law, 2C-7-2F and G are the removal portions of the statute. 2C-7-2F and G allows the person, the registrant in this case, to petition the courts for removal from his Megan's Law obligation. In order to qualify for removal, they must meet the following criteria. They must be offense-free following any term of incarceration for 15 years. To be clear, an offense is a crime in the state of New Jersey, and it could be a disorderly persons offense. Having a disorderly persons offense could bar someone from removal from Megan's Law. In addition to that, They must show they are not likely to pose a threat to the safety of others. Typically, this is done through a psychiatric or a psychological evaluation from an expert. Testimony may be needed at the time of the hearing to prove that. In addition, they may not have been convicted or adjudicated delinquent or found not guilty by reason of insanity up to C14-2A, aggravated sexual assault, or 14-2C1, sexual assault with a degree of violence, or more than one sex offense as described previously in 2C7-2B. Currently, there's a lot of litigation in this area of Megan's Law. It continues to evolve in the court system. Courts have found recently that lifetime registration does not violate the ex post facto clause of the Constitution as it applies to adults. However, recently, in the matter of CK, they have found, the Supreme Court of the state of New Jersey, that is, has found that lifetime registration of juveniles is unconstitutional. Under Megan's Law, these are the general Megan's Law crimes. Failure to register for Megan's Law initially is a violation of 7-2A. It is a third-degree offense, and again, carries a maximum penalty of 5 years, as all third-degree offenses do. If a person fails to verify their address, whether it's an annual failure to verify or a 90-day failure to verify, that is also a third-degree offense, or third-degree offense under 7-2E. 7-2D covers failure to notify changes of address or failures to register at a new address. It also deals with failures to register the change of employment or school enrollment status. Anyone who provides false information during the registration process is subject to a violation of 7-2E. And again, failure to notify law enforcement of access to an internet access device is a violation of the third degree under 2C7-2D, as in David 2. Please note that anybody with a conviction for a failure to register under Megan's Law could later along down the line prevent them from being removed from their Megan's Law obligation under 2C7-2F or G. Every time a registrant comes into a police department and registers, what happens is that registration then gets sent to the local prosecutor's office. The prosecutor then has an opportunity to review the discovery in the matter and sets forth what's called a tier hearing. The tier hearing is done before a superior court judge. Typically, there is a Megan's Law assigned judge for each county. The prosecutor will send forth what's called a statement of reasons along with a registered risk assessment scale to the judge and to a defense attorney if there is one. They will then have an opportunity to be heard in front of the judge, and the judge will make a determination about notification and the level of notification that goes out into the community. The prosecutor asks for the particular scope. These hearings are quasi-civil, and the court uses a standard of, are they likely to encounter the victim class in their daily living when they review these? The notification in these matters are geographic in their nature and differ slightly between urban, suburban, and rural designations. All of these tier hearings are sealed and are not available to the public at large. Megan's Law is strictly confidential. Tier information can only be released by a county prosecutor's office for a legitimate law enforcement purpose. And the only persons generally present at a tier hearing are the court staff, prosecutor, the registrant, and the registrant's attorney. Registrants, if they qualify, may have the services of a public defender for the hearing. Registrants may object to the tier, scope of notification, and any other issue. The court relies on the clear and convincing evidence standard when making their determination. Tier hearings fall into one of three basic categories. The first is the initial tier. That is the first time that a registrant is tiered for their Megan's Law eligible offense. There is what's called a re-tier. A registrant is re-tiered if they commit a subsequent Megan's Law offense. And they're what are generally referred to as motions to amend. Registrants are generally tiered every time they move. As a result, there could be changes to the criteria, or the registrant could file a motion to reopen the tier hearing based upon new information. For example, passage of time or a new psychological report. Most of the general public believes all sex offenders are on the internet. That is incorrect. All tier 3s are on the internet. Many tier 2s are on the internet, but there are exceptions, and most tier 1s are currently not on the internet. The 3 levels of tier are tier 1. Tier 1 is low risk. The local police department and the county prosecutor's office are aware of the registrant's location. If the prosecutor makes an initial tier 1 finding, no tier hearing is generally scheduled. They are considered low risk. However, if the offense occurred after July 1st, 2014, and this is important, and there was a finding of repetitive and compulsive at the time of sentencing, then the registrant will be on the internet. Tier 2 is the moderate risk sex offender. In addition to the local police department and county prosecutor's office, staffs of schools, community groups that are registered with the local police department, daycares, women's shelters, household members, and potentially the internet will be notified. There are 4 exceptions to internet notification. The first one is if the registrant was adjudicated delinquent and committed only 1 sex offense. The second exception is that the registrant was convicted of an incest crime and committed only 1 sex offense. The third is that the registrant was convicted of a sexual offense where there was consent, but legally the victim was unable to otherwise give consent, and the registrant committed only 1 sex offense. And the fourth is that the court has determined that no notification is necessary. An example of each would be if a registrant was adjudicated delinquent and only committed 1 sex offense, is just that. They were a juvenile, and the reasoning behind that is juveniles are still developing and they make mistakes, and they don't want to publish a child's name when they have an opportunity to grow and move past it. The second, if they were committed of an incest crime and only 1 offense. And the reasoning for that is essentially they don't want the victim's name to be published and linked with that individual, and it's on behalf of the victim. The third is a case that's very similar, where it's a case where it's commonly referred to as statutory rape. Where the age of the parties differ, you may have a 20-year-old defendant who is dating a 15-year-old victim. The victim at age 15 could not legally give consent to participate in a sex act legally. However, otherwise the act was consensual, and therefore publication is not necessary. The court ordered notification. Something came up at the hearings, which the court read into and decided that this is not a sex offense. For example, certain kidnappings may not be sex offenses. It might be more familial in nature, and therefore publication is not necessary. Tier 3s are high risk. Those are considered the most dangerous sex offenders. In those cases, there is notification to the local police department, the county prosecutor's office, schools, and that would go to staff and students, community groups, daycares, internet. If convicted after 2011, registrants could have to wear a GPS monitoring bracelet. There is door-to-door notifications to homes and businesses, and there are no internet exceptions for Tier 3 offenders. The Sex Offender Internet Registry can be found at www.njsp.org. The site is maintained and run by the New Jersey State Police. Again, all tier 3s are on the internet. All tier 2s are on the internet with 4 exceptions. Tier 1s who were convicted after July 1st, 2014, and were found to be repetitive and compulsive are also on the internet. If a convicted sex offender is incarcerated, they are not on the internet because they are incarcerated and we know where they're at. The website allows several different types of search options, including by name, town, or geographic area. I previously mentioned the Registered Risk Assessment Scale, more commonly referred to as the RRAS. This is a tool that the prosecution uses to determine the risk of recidivism and the level of notification necessary to safeguard the community. It is a weighted scale with 13 criteria. The criteria are determined to either be low, worth 0 points, moderate, worth 1 point, or high, worth 3 points. Weighting process may take into account any information available. Prosecution is not limited to the plea agreement. Prosecutors may rely upon all credible evidence available to them. For example, in a case where a defendant were to plead guilty to endangering the welfare of a child, and the factual indicated a case where he pled guilty to grabbing the buttocks of a young child and squeezing them for a sexual gratification. And that's the factual basis. However, if the discovery upon review of the prosecutor shows by clear and convincing evidence that a sex act of penetration occurred, the prosecution is able to look at that as it was a sexual assault rather than endangering the welfare of a child. The RRAS score determines the level of tier. If the point total is 0 to 36 points, that person is a tier 1. If it falls between a 37 point to a 73 point score, that person is a tier 2. If it's 74 points to 111 points, that person is a tier 3. The first grouping of criteria are called the seriousness of offense category. It carries a modifier of ×5. The first criteria looked at is degree of force. There's low risk. That would be an offender who attempts to obtain sexual gratification through use of candy, pets, or other non-violent methods. Consent would be an excellent use of low risk. Moderate risk. There was a threat of physical harm where they did apply force that coerces but does no physical harm. High risk would be violence, threatening at gunpoint, for example, or knife point. If there was substantial physical damage would be another excellent example of high risk. The maximum total of points that a registrant could score is 15. The second criteria is degree of contact. Low risk would be none, or fondling over clothes. Moderate risk is fondling under clothes with no penetration. And high risk is penetration of any type, whether it be oral, anal, vaginal, or digital. There's a maximum of 15 points in those categories. The age of the victim. Low risk is anyone 18 years of age or older. Moderate risk would be between 13 and 17, and high risk would be a child less than 13. Again, the maximum total in that grouping is 15 points. The next grouping is called the offense history categories. It has a modifier of ×3. Victim selection, if it is a household or family member, it's considered low risk, because please remember, Megan's Law is designed to protect the community at large, and if it is a family member, they're less likely to offend against the public. Moderate would be an acquaintance, and high risk would be a complete stranger. for a maximum of 9 points. The number of offensive victims is the fifth criteria. And a conviction is not necessary. Multiple incidents with the same victim are addressed in criteria 6. A low-risk example would be interfamilial abuse of one child, one stranger. Moderate risk would be 2 victims, even if it was one event. High risk could be 3 or more separate victims, with a maximum total of 9 points. Number 6 is the duration of the offensive behavior. Low risk would be a one-time act or acts that occurred over less than a year. Moderate risk would be between 1 year and 2 years. And high risk is anything more than 2 years, for a maximum score of 9 points. 7 would be the length of time since last offense, and this refers to the last sex offense, not last conviction. Low risk would be 5 or more years since the last sex offense. 5 or more years since last sex offense. Moderate risk would be at least 1 year, but less than 5 since the last sex offense, and high risk would be less than 1 year, for a maximum total of 9 points. History of antisocial acts. Low risk would be if the only conviction was the sex offense, it would be low risk. Moderate risk would be 3 or fewer documented acts or convictions. For this purpose, things like restraining orders, violations of probation or parole could be used to increase the risk. High risk would be an extensive criminal history of at least 4 or more convictions or acts. Again, the maximum number of points is 9. The third grouping of criteria are called the characteristics of offender. It has a modifier of ×2. The first under criteria 9 is response to treatment, and that applies to sex offender treatment only. A therapist's report is necessary to rate this criterion. A low risk would be no treatment, good progress in sex offender treatment. A moderate risk would be some progress, but limited treatment difficulties. And high risk would be no progress or 1 or more offenses while in treatment, with a maximum total of 6 points. Number 10 is substance abuse. A low risk would be a no history of abuse. A moderate risk would be a historical abuse, but in remission or episodic use. And high risk would be current dependence, for a maximum of 6 points in those criteria. The fourth set of criteria is labeled community support. It has a modifier of ×1. The first is therapeutic support. That is low risk, they're currently in treating. Moderate risk would be intermittent treatment, and high risk would be no treatment at all. The maximum total is 3 points. Residential support under criteria 12, low risk, they're living in a supportive or supervised setting in appropriate locations, such as a rehabilitation facility or living with family. A moderate risk would be living in an appropriate setting without support. And a high risk would be a problematic location, homeless, or living with deviance. That would be a maximum total of points of 3. Under education or employment status, low risk would be full-time or full-time employment or school, or if they're collecting SSI or SSD, or retired if age appropriate. Moderate risk would be part-time employment or school, and high risk would be none at all, for a maximum total of 3 points. Again, the first 6 criteria are what are known as the static factors. Once they are set at the initial tier hearing by a court, they do not change unless there was a gross mistake or there was a new sex offense committed, and then the person is re-tiered. The dynamic factors are 7 through 13, and they're dynamic in that they can change due to new events, such as the passage of time or therapy or employment. Both the state and the defense can petition the court to deviate from the registered risk assessment scale score. It is typically referred to as a motion for an out of the heartland exception. The case that started that is In Re GB, which is listed at 147 New Jersey 62. It allows the court to look at cases which may have unusual facts where relevant material exists, but the RRS does not account for them. For example, child pornography is not your typical sex offense in that there is no touching by the registrant of the victim. And depending upon what the images are and what they pertain to be, could lead to an event where an out of the heartland exception for the state may look to have that person put on the internet. An example for defense to use an out of the heartland exception, if there is a new psychological report showing great progress in treatment, that might be a reason to go to a downward departure. One thing clear about Megan's Law is Megan's Law cannot and does not dictate where an offender resides. Megan's Law does not prevent an offender from living across the street from a school or anything of that nature. It is simply about notification and registration. Many registrants of Megan's Law are subject to what is called community supervision for life or parole supervision for life, but not all of them. Both community supervision for life and parole supervision for life are supervised by the New Jersey State Parole Board. Community supervision for life is commonly referred to as CSL. Registrants who were convicted of certain sexual offenses between October the 31st of 1994 through January 13th of 2004 are subject to CSL. Registrants who violate CSL are prosecuted under 2C 43-6.4D, and they are entitled to a trial by jury. It is currently a fourth-degree crime. There is a recent case, State of New Jersey versus Hester, which recently came down from the Supreme Court of the State of New Jersey in May of this year, which made a 2014 amendment to the statute as unconstitutional as violating the ex post facto clause of the Constitution. So at the present, CSL is currently only a fourth-degree crime. Parole supervision for life, or commonly referred to as PSL, that indicates registrants who were convicted of certain sexual offenses after January the 14th, 2004. They are subject to the PSL. Violations of PSL are entitled to a parole board hearing. Registrants may petition the court for removal of both CSL and PSL after 15 years. And a registrant may be subject to CSL and PSL both if he or she has multiple convictions. I have also provided you with a list of offenses and whether or not they are CSL and PSL. For example, aggravated sexual assault is subject to Megan's Law. It is subject to CSL if it occurred between 10/31/1994 and January the 14th, 2004. However, if you look at criminal restraint, it is subject to Megan's Law, but it is not subject to CSL and PSL if the victim was an adult.
Thank you, Matt. We're going to hold all questions until the end. So next we have Stephanie Lutz, Assistant Deputy Public Defender. Ms. Lutz has been with the New Jersey Office of the Public Defender since 2016. She works in a special hearings unit, which deals primarily with Megan's Law matters. Good morning, Stephanie.
Good morning, Michael. Thank you so much for the introduction. I'm very grateful for the opportunity to speak to you all today. I really enjoy practicing in this area, and I look forward to sharing with you some of what I've learned in my practice. So I'm going to skip over some of my introductory slides just so we can get to the substance and the nuts and bolts of Megan's Law. These slides will be available to you once this presentation is posted online. Okay, so who is covered by Megan's Law? This graphic represents a visual depiction of the entire Megan's Law process from the the start of Megan's Law to removal from Megan's Law. And you can see this sort of pathway in the middle here, Megan's Law requirements, that represents everything that the registrant is required to do while he or she is subject to Megan's Law. So we'll start with the on-ramp. That is NJSA 2C7-2B. And it's not called the on-ramp in the statute, that's just my name for it. This is the list of qualifying offenses that will subject you to Megan's Law. It is a conviction, adjudication of delinquency, or finding of not guilty by reason of insanity of a qualifying sex offense in New Jersey, or a similar crime in another state. Also, even if we put aside the qualifying offenses, if you're required to register as a sex offender somewhere else and you work in New Jersey, or if you go to school in New Jersey, you have to register under Megan's Law in our state. There's actually a small typo on this slide. The fourth point, it says registration requirement elsewhere, but live or work in New Jersey. It should say go to school or work in New Jersey. But certainly if you're convicted of a sex offense and you live in New Jersey, you're also going to be subjected to Megan's Law. Assistant Prosecutor Spence went through the qualifying offenses in detail, so I'm not going to go over that again, but the list is available in the statute 7-2B. And I should say that the entire Megan's Law statutory scheme is contained in Chapter 7 of our criminal code. In the GAN 2C publication, Megan's Law takes up about 25 pages, so you can easily read it in an afternoon. Okay, so we've gone up our on-ramp. We are now subject to Megan's Law. What does that mean? I've broken it down into 4 main areas: registration, tiering, notification, and a requirement to avoid youth-serving organizations for certain offenders. Now, I'm presenting from the registrant's perspective, so I want to point out a key principle that you should keep in mind. Most registrants have the same overarching goal with respect to Megan's Law, and that is this: they want to preserve their privacy and their reputation as much as possible. And what that is going to mean is limiting the scope of community notification. That will enable them to maintain their privacy. in the Tier 2 notification. They're also going to get residential door-to-door notification. Prosecutor's office is going to send a representative, and they're going to knock on the doors of the registrant's neighbors and hand out a document explaining that a sex offender lives in their neighborhood. Internet registration is mandatory for Tier 3s. Unlike Tier 2, there are no exceptions. If you're a Tier 3, your information is going on the internet. There's no ifs, ands, or buts. And finally, Tier 3 can implicate GPS monitoring in some cases. Okay, so I mentioned there are exceptions to internet notification for some Tier 2 registrants. If you're a registrant or if you are representing a registrant at a tier hearing, it is imperative that you are familiar with these exceptions. These can make a huge difference in the registrant's, in the outcome of their case. Okay, so I'm going to go through the exceptions one by one. Assistant Prosecutor Spence already discussed these, but they bear repeating. The first is the juvenile exception. If you were a juvenile at the time of your sex offense and you were adjudicated delinquent, and if the offense involved only one victim and only one occurrence, so just one incident of offending behavior, no more, your information can be excluded from the internet site. Okay, the next exception is the household or the incest exception. This is the case where the offender was related to the victim, or the offender stood in loco parentis with respect to the victim, and both the offender and the victim lived in the same household. And I'm just going to pause for a moment. We're just working with the presentation here. Okay. So finally, we have our consent exception. This is the case where the victim, for whatever reason, agreed to participate in the sexual activity, but they were underage, so they couldn't legally consent, but they agreed to participate in some activity. And this applies similar to the juvenile exception, only when there's one victim and one incident of offending behavior. Of course, it's not that simple because in 2014, the legislature amended Megan's Law and said that anyone who was found to be repetitive and compulsive is going on the internet. These exceptions don't matter. So if you were found RNC, you may not be able to avail yourself of these offenses, but it's going to depend on the date. If you're representing someone in a tiering, please familiarize yourself with this case, LA v. Hoffman. It discusses the application of that amendment. Okay, and again, we're experiencing some technical difficulties, so I apologize if you're hearing me pause. Okay, so moving on. So that was the community notification part of this. So now we're going to talk about tiering. So this is really the opportunity for advocacy with Megan's Law. Again, you've seen this slide before. A registrant's tier determines his or her level of notification, but there are exceptions. In Doe v. Poritz, that was included on my introductory slides, which I skipped over, but Doe v. Poritz, it was decided by the New Jersey Supreme Court in 1995. The court held that Megan's Law is constitutional. But the court said that procedural due process is required for registrants who are facing tier 2 or tier 3 notification. This tier hearing is that due process. So the hearing is going to occur in the county where the registrant resides. It is before a superior court judge in the law division. The prosecutor's office is going to propose the initial tiering, but the registrant absolutely has an opportunity to object to that proposal and to ask the court to lower the score or to minimize the notification. Prior to the hearing, prosecutor, as I said, they're going to propose the tier and the scope of notification. They're going to notify the registrant of their proposal. They will inform the registrant of a hearing date. That's the very important date where the registrant can go before the court and make objections and make arguments on his or her behalf. Registrant is entitled to counsel at these hearings. Registrant is also entitled to discovery from the prosecutor's office. At the hearing, little different than perhaps the typical criminal court procedure that you're used to. The hearings are closed to the public, the records are sealed. Registrant is not required to attend, so there's not going to be a bench warrant issued if registrant doesn't show up. It's probably in the registrant's best interest to attend, but he or she is not required. Counsel can appear on registrant's behalf and waive the registrant's appearance. So huge thing for the registrant right here. The burden is on the state to establish the tier and the scope of notification by clear and convincing evidence. So if the state wants a tier 2 notification, the state has to prove that that is what is required. Registrant can present evidence to show that the state hasn't met its burden. And I can explain more about how to do that. So how exactly does this all work? AP Matt Spence already talked about this, but it's the Registrant Risk Assessment Scale, also known as the RRAS. There are 13 categories on the scale that are associated with the risk of sexual reoffending. Each category gets an individual score, and then all the scores are added up for an overall total. And that total will then dictate the tier classification. Very important to note, the Registrant Risk Assessment Scale carries with it a presumption of accuracy. What does that mean for the registrant? It means, although you can go to your hearing and make objections, and you should, you cannot go into the tier hearing and say, I disagree with the Registrant Risk Assessment Scale. It's outdated, or it doesn't comport with more recent research about sexual reoffending. That's not going to fly. Our case law tells us that Megan's Law judges must presume that the RRAS is accurate. But there are still other opportunities to challenge the proposed tiering and scope of notification. So here's what the scale looks like. As I said, there are 13 distinct factors. Each factor gets a score. AP Spence already went through each factor and told you what facts they are considering. Oops, I skipped ahead. So just an example of how a registrant might advocate for a lower score. So I made this scale up. This is not related to any real person. But let's say that this is the scale that was proposed by the prosecutor's office. Registrant is going to receive it, review it, or registrant's counsel. And you're going to say, all right, well, they're proposing a final score of 38. 38, if you look down here at the score ranges, that's just over the threshold for moderate risk or tier 2. Registrant, as I said, is probably going to want to limit the scope of notification. They're going to want to preserve their privacy and get to that tier 1 classification. So registrant is going to say, well, if I can reduce this by 2 points, I'll be at a 36. And that will put me in the tier 1 range where there is no community notification. So registrant might go through these factors and say, okay, has this been scored correctly? Are there opportunities here for me to reduce scores on any one of these factors? And let's say they look at factor 13, employment or educational stability. Well, the prosecutor has proposed intermediate but appropriate, which is going to give a point. Well, registrant must say, hey, that's incorrect. I've actually been working full-time permanent position for the past year. That is stable and appropriate employment. So what the registrant could do is bring pay stubs to the tier hearing or bring a letter from their employer to prove that their employment is in fact stable and appropriate. The judge would review that documentary evidence, and if he or she finds it credible, they're probably going to reduce this score on factor 13, and that's 1 is going to become a 0. So you're now down to a 37, and you would again want to go through and try to do that again on any of these other factors if possible. As AP Spence explained, some of these scores are static factors. So factors 1 through 8, with the exception of 7. What that means for the registrant is this. Static factors are historical. They have to do with events that happened in the past, usually relating to the sexual offense. They have already happened. They're done. Nothing is going to change what happened in the past. So once those scores are set at the first tier hearing, they cannot be changed unless there's some extraordinary circumstance. Res judicata attaches to these scores. If you're representing someone at a first time tiering, or if you're a registrant representing yourself, it is very important that you get these static factors as low as you can at that first tiering, because once they're set, they are not going to change. The bottom part of this scale is, these are the dynamic factors. These change over time. They focus more on what the registrant is doing in the present, which is of course going to change over time. So any subsequent hearing, you will have an opportunity to change these dynamic factors. Okay, as I mentioned, documentary evidence, hearsay is permitted as long as it's credible, and the judge is going to make that call. Court is going to consider your worst offense. So if there's multiple offenses, whatever the more serious conduct was is going to be counted against you. And as AP Spence mentioned, the court will consider conduct that was not the subject of a conviction, as long as the evidence of that conduct is credible. But again, the state bears the burden here, so registrant can challenge any evidence put forth by the prosecutor. And if you're representing someone in this area, you absolutely need to obtain these guidelines. These are the Attorney General's Megan's Law guidelines. You can get them for free online. These guidelines are a comprehensive review of Megan's Law. Very well organized, well written, easy to understand. Exhibit E of these guidelines is going to explain the tiering process in detail. Megan's Law judges rely extensively on these guidelines in scoring the RRAS. So you absolutely need to understand how the guidelines work and how the factors are scored before you go into your tiering. That will improve your ability to advocate for yourself and get the lowest score you can. As I said, the RRAS is presumptively accurate. Courts are going to give a great deal of weight to this scale. However, it can be overcome, and that is that principle comes from our Supreme Court's decision in re JB. If you are a registrant or you advise registrants, this case will be helpful to you. GB says that in some unique cases, the RRAS results can be overcome if the registrant can prove that his case or he himself falls outside of the heartland of Megan's Law cases. And registrant can provide expert testimony to that effect. A good example of this is a registrant who has aged. Perhaps the offense happened when they were a young, in their early 20s, and they're now a middle-aged person. Research in the field of sex offense reoffending shows us that risk of reoffense decreases with age. So you may be able to overcome the registrant risk assessment scale results in that case, but you're going to need an expert evaluation to support your position. GB also says that even if the registrant accepts the tier classification, they can still argue that the scope of notification dictated by that classification is excessive. And I'll give you an example of that so it makes more sense. Imagine you have a registrant who is scored on the scale, and the score comes out to be in the tier 2 range. Registrant has sort of reduced the scores as much as possible, but the facts are what they are. The score is never going to be a tier 1. But imagine that this same registrant is perhaps paralyzed, perhaps physically incapacitated. Maybe they're unable to walk, they're unable to get around without a wheelchair. So you might argue that that individual just simply isn't able to go out into the community to commit another sex offense. And so in that case, community notification might be excessive. Obviously, that's just an example. The judge isn't necessarily going to agree, but you could certainly make that argument that the scope of notification would be excessive. So in sum, GB, very important case for registrants. It says you can challenge the actual score on the RRAS, the individual scores for the factors. It says that you can provide expert testimony to explain or to prove that your risk is actually lower than what the RRAS says. And finally, you can argue that the scope of notification called for by your tier is too much in your specific case. So what happens in those cases is you actually can overcome the significant weight given to the RRAS, but these cases tend to be rare. Okay, so in conclusion, for our tier classification, the court is going to consider static factors, dynamic factors, and any arguments made by the registrant under In Re JB. The court is then going to order a tier classification. And very briefly, Megan's Law prohibits certain sex offenders from participating in youth-serving organizations if the registrant's victim was a minor. You can refer to the statute for details about that. It's 2C7-2, 22, and 23. Moving on, we are now at the end of our Megan's Law process. We are on the off-ramp, although you'll see quickly that not everybody can get to this point. The off-ramp is NJSA 2C7-2F. This is the statute that explains how a registrant can be removed from Megan's Law. The Supreme Court paraphrased or explained this statute in Doe v. Poritz. I call the procedure in my own practice a motion to terminate Megan's Law requirements, or a removal motion. You're going to file it in the law division where the registrant lives. You cannot use e-courts, you have to use paper, and you have to meet the standard in subsection F, which I will explain now. Under subsection F, the registrant must prove that he has not committed an offense within 15 years following conviction or release from incarceration for any term of imprisonment imposed. He also has to prove that he's not likely to pose a threat to the safety of others. And as AP Spence already told you, an offense is not just a sex offense. It's any crime, disorderly person, or petty disorderly person. I often have to give registrants the very bad news that their kind of minor CDS, possession of marijuana crime is going to pose a big problem for them when they try to get off of Megan's Law. Okay, so the first part of the standard is, I think of this as the objective part, or the timeline part of the standard. You haven't committed an offense within 15 years following your conviction for Megan's Law, for your sex offense. Current issue right now in the world of Megan's Law surrounds this 15-year period. The issue is this: what happens if you commit a CDS offense? If you're convicted of a CDS offense 5 years after your Megan's Law offense, does that 15-year clock restart and you get another chance to accrue 15 offense-free years? Or are you stuck? Is that the end of the road for you? You've screwed up in your first 15 years and that's it. You're on Megan's Law for life. Obviously, as an advocate for registrants, I argue that the clock would restart and you get another chance to accrue that 15-year offense-free period. This issue is currently pending in the appellate division, so stay tuned for an answer. Again, second part of this standard, this is the subjective part. You're not likely to pose a threat to the safety of others. The best way to prove this is to have the registrant evaluated by an expert in the field of sexual risk assessment. You would then attach the expert's report to your moving papers and show the court, hey, this registrant, they're not going to reoffend. You can remove them from Megan's Law. Okay, but of course, it's not that simple. In 2002, the legislature amended Megan's Law. They added subsection G, and subsection G says if you were convicted of more than one sex offense, or you were convicted of aggravated sexual assault or sexual assault using force, you're never getting off of Megan's Law. Megan's Law is a lifetime requirement for you. So what does subsection G do to our graphic? Well, it does this. It blocks the off-ramp. You're not going down that off-ramp. You're on Megan's Law forever. And so for someone subjected to subsection G, Megan's Law looks like this. Few issues around subsection G. Well, okay, so you're ineligible if you've committed more than one sex offense. What if you have one judgment of conviction with multiple counts? Perhaps it was multiple incidents with the same victim on the same day. Is that more than one sex offense for the purpose of subsection G? Another issue is whether subsection G applies to individuals who were convicted prior to its effective date in 2002. As AP Spence explained, the retroactive application, the appellate division held that the retroactive application is not an ex post facto violation, but there is a remaining question out there, which is whether the legislature intended Megan's Law, intended this amendment to apply retroactively in the first place. And that issue is pending in the appellate division as well. Very quickly, collateral consequences. There are many from the registrant's perspective. Big ones are housing. Many registrants are low-income individuals. They rely on public housing, public assistance for housing, highly regulated housing situations. And as you can imagine, a lot of these housing providers have prohibitions on for Megan's Law registrants. Another big one is harassment and vandalism. Certainly if someone's information, their address is out there on the internet, they are often subjected to harassment in their community, and that harassment unfortunately extends to the registrant's family members who also live in that at that address. Finally, some dispositional options. If you're representing an individual in a criminal case and that person is charged with a sexual offense and you want to resolve the case, try to plead your client out to a non-Megan's Law offense. Refer to the statute for what offenses qualify for Megan's Law and try to avoid them. Also try to avoid offenses that would trigger parole supervision for life. And if you have to, if it's going to be a resolution to a Megan's Law offense, at least try to avoid aggravated sexual assault or sexual assault with force, because those are going to require lifetime registration. Finally, a Horn hearing. If your client is charged with a sexual offense, they're going to be evaluated at the Adult Diagnostic and Treatment Center. If that evaluation results in or it could result in a determination of repetitive and compulsive, you may want to challenge that determination at a Horn hearing, because the repetitive and compulsive designation has negative consequences for registrants. I'm going to skip our frequently asked questions so we can get to your questions. And with that, I will conclude my presentation.
Thank you very much, Stephanie and Mark, for your presentations. I understand we lost the slides for a period of time. I'm not sure if they're back up yet. However, once we upload this onto the NJAPS website, we should be able to get those slides up for everybody to see. We have several questions that have come in. We'll try to answer as many as we can over the next several minutes. First, I guess, Matt, what would happen if the offender works as a computer tech or his business is all about computers?
Under Megan's law, it's not an issue as long as it is disclosed that he has access to internet access device. That person may come into some difficulty if it violates or is in violation of some of the rules of parole that he may be subject to if that person is subject to CSL or PSL, because employment must be approved generally by parole, and depending upon what the job entails, it may curtail some of that registrant's ability to do that job with computers.
Thank you. Stephanie, there are references to the offender wanting to preserve their privacy. Why is that important to the community?
I'm so glad we got this question. I was actually going to include this in my presentation. I certainly imagine that there are people out there listening today thinking, wait a minute, we're talking about convicted sex offenders. Why do I care about their privacy? The answer is you certainly don't, and I certainly understand why you wouldn't care. I represent registrants, so I have to advocate for their best interest, and they are certainly concerned with their privacy. So I would certainly never try to convince you that you should care about registrants in your personal life. But there are people out there who are on Megan's Law, or who have family members or loved ones who are on Megan's Law, and they absolutely want to preserve their privacy.
Thank you. So Matt, can an offender convicted and placed on Megan's Law in New Jersey, who then moves to another state, not be placed on Megan's Law?
The answer to that is it depends. It depends on what state they move and what that state's rules are regarding Megan's Law. Megan's Law does not restrict movement. A sex offender is entitled to move under the U.S. Constitution. If they do move, they will have to register in the other state. If the other state looks at their conviction and decides that is not one of our convictions that need registration, then they will not have to register in that state. However, if they do move back to New Jersey, they would have to register in New Jersey.
Yeah, thank you. And Stephanie, you mentioned subsection G in your presentation. Does that only apply to adult offenders, not juveniles?
Yes, as of a few months ago, subsection G only applies to adult offenders. In Re CK, I don't have the date in front of me. The New Jersey Supreme Court issued their opinion recently. Actually, here it is, April 24th, 2018. The court held that subsection G does not apply to juvenile offenders.
Thank you. In both of your presentations, you made reference to the law division in as far as tiering goes. Does that mean it's not in the criminal court?
Typically, the judge who is assigned to hear the Megan's Law cases is a criminal sitting judge. So it is heard by a criminal division judge typically. But the nature of what Megan's Law is in and of itself is civil in nature.
Thank you. I get through all of our questions. Thank you both, Stephanie and Matt, for coming out and presenting on this topic today. This is the first in a series of 5 webinars. The recorded version will be uploaded within 2 weeks to the njatsa.org website. Our next webinar will be on July 17th at 10 a.m. and will focus on the prosecution and defense of juvenile offenders. Thank you to all participants who listened, and have a great day.